Judgment in the appeal, Virgin Atlantic Airways Limited against Zodiac Seats UK Limited.
Lord Sumption will announce the decision of the court.
This appeal is about res judicata, the traditional Latin term used to refer to the principle of law, which applies in civil litigation and prevents the same parties from litigating the same matter twice. Sometimes 2 words in Latin can pack as much punch as 20 in English. It is an important principle because it is contrary to the public interest for the same matter to be repeatedly reopened between the same parties, thus preventing the courts from achieving finality in the resolution of the dispute. As usual, however, in these cases, the real problem is to decide whether it really was the same matter which was being litigated on the second occasion. The circumstances of this case are highly unusual. In 2007, Virgin Atlantic obtained a European patent for a design of flatbed for use on long-haul flights. A European patent is granted by the European Patent Office and takes effect in every country of the European Economic Area for which it is granted. In the United Kingdom, effect is given to it by Part 2 of the Patents Act 1977. One of the more problematical aspects of the European patent scheme is that the European Patent Office and the English courts both have concurrent jurisdiction to deal with challenges to the validity of the patent. Only the English court, however, has jurisdiction to deal with claims for the infringement of a European patent in England. What happened in the present case was that a number of parties began proceedings in the opposition division of the European Patent Office to challenge the validity of the patent, mainly on the ground of prior art, i.e. on the grounds that an invention, which was the same in all relevant respects, had already been made and published by someone else. Virgin defended the challenge in the European Patent Office and simultaneously sued Zodiac in the English High Court for infringing the patent by manufacturing flatbeds said to be covered by its terms. Zodiac defended the action in the High Court by contending, among other things, that the patent was invalid. They relied on the same prior art which was being relied upon to challenge the patent in the European Patent Office. So there was a challenge to the validity of the patent on substantially the same grounds in both the European Patent Office and the English High Court. Unfortunately, they arrived at diametrically opposed conclusions. The Court of Appeal in England held in October 2009 that the patent was valid and that Zodiac had infringed it. They specifically rejected the challenge to validity based on prior art. In January 2010, they made a declaration to that effect and ordered an inquiry as to damages which Virgin had suffered. 8 months later, in September 2010, the Technical Board of Appeal of the European Patent Office ruled that all the claims in the patent which the Court of Appeal had held to be infringed were invalid on the ground of prior art and directed the amendment of the patent by deleting from it all of those claims retrospectively back to the date on which the patent had been granted. The result of that decision was that in law, the patent must be treated as never having existed in the form in which the Court of Appeal had held it to have been infringed. But, said Virgin, that was irrelevant because the Technical Board of Appeal had pronounced on the point too late. By then, the Court of Appeal in England had already decided that the patent was valid and the parties were bound by that, whatever the Technical Board of Appeal might subsequently decide. It followed, they argued, that on the inquiry as to damages for infringement, which had not yet begun, the English court must assume that the patent was valid and infringed, even though the authority which had granted it had effectively revoked it retrospectively on the ground that it was invalid and incapable of being infringed. The Court of Appeal accepted this argument, as they were bound to do because of previous Court of Appeal decisions in which the same argument, or a very similar one, had succeeded. The real question on this appeal is whether those earlier decisions were right. The Supreme Court unanimously decides that they were wrong and must be overruled together with the Court of Appeal's decision in the present case. They do so for 2 related reasons. The first is that even when the very same cause of action is in question in the inquiry as to damages, as was relevant at the trial on liability, the rule which prevents the matter from being reopened is not absolute. It applies only when the very point being raised was raised and decided on the earlier occasion, or where it was not raised but could and should have been. The decision of the Technical Board of Appeal of the European Patent Office was a major development in the dispute between the parties, which could not have been raised at the trial on liability or in the appeal to the Court of Appeal because it had not yet happened. The second reason is that Zodiac are not trying to rely on the same point in the inquiry as to damages as the Court of Appeal rejected in the trial on liability. The point which the Court of Appeal rejected was that the patent was invalid. The point which Zodiac want to raise in the inquiry into damages is that it has, in the relevant respects, been revoked by the authority which granted it. It is true that the reason why the patent has been revoked is that it was invalid, but what matters is the mere fact of revocation, not the reason for it. The fact is that in law there has not and never has been a patent in the form said to have been infringed. That is a new and conclusive development. This conclusion means that the outcome of disputes like this one, which is not particularly unusual, will not in the majority of cases depend on the largely fortuitous question which tribunal, as between the High Court and the European Patent Office, concludes its proceedings first. However, there will still be some cases in which damages will actually have been assessed and judgment given for a sum of money, when it will usually be too late to reopen the question of liability. The Supreme Court therefore concludes its consideration of this appeal by suggesting that the Patents Court and the Court of Appeal should re-examine their procedures in cases where validity is being challenged simultaneously in both tribunals, with a view to avoiding a similar conflict between inconsistent results in future, so far as this can justly and conveniently be achieved.
Thank you.